Auriol Gray has had her manslaughter conviction quashed by the Court of Appeal, and the reason is somewhat surprising, to say the least. I've seen one or two comments already on the previous videos I did about this case, and I've even had a message from Charlie Veach asking about this case. So despite me still struggling to talk, I thought I'd do a quick video to explain why this is, because it's a bit of a technicality in one sense. If you're not familiar with what this case was, it was a very sad case where Mrs. Ward was cycling on what was believed to be a shared pedestrian and cycle pathway, which was the subject of a very heated debate, which is better left for another video. She was cycling towards Auriol Gray, who gestured in anger towards her for being on what she believed to be the pedestrian footway. And then sadly, Mrs. Ward wobbled and fell into the road and was hit by a car and sadly died. Auriol Gray also said, "Get off the effing pavement," I paraphrase, and there was a whole question mark over whether or not any contact was actually made, and the question as to whether this amounted to an assault, which is actually very relevant to this case. So before I go into the reasoning as to why this conviction has been quashed, let's just have a brief overview of manslaughter. In this case, unlawful act manslaughter or dangerous act manslaughter. That is where there's an underlying offence or an underlying dangerous act which led to and caused or had a significant impact in the death of another individual. And so in this case, it ought to have been that there was an unlawful act which would ordinarily be some form of assault which resulted in somebody's death. Because for manslaughter to occur, as opposed to murder, where the intention is significantly different, there might just be an underlying unlawful act, such as assault, which then results in somebody's death. Think about it: if you punch somebody in the face and that's deemed to be unlawful, and there's no self-defense successfully made out as to why you punched somebody in the face, then the punch would be an assault. If that person fell over in shock or loss of balance or whatever it might be from that original punch, they hit their head, they have a brain bleed perhaps, and then die as a result of the injuries. That could then be manslaughter. So in this case, the reason it was surprising is that that underlying offence wasn't really addressed. Now, if I take you to the Court of Appeal judgment here, it is explained in the round. I mean, this is available online. You can read it in full for a fuller understanding. I'm going to summarise somewhat here. The Court of Appeal here referenced to the summing up of the original case, which in itself, I believe, was a retrial. The court said that the judge described in the summing up the respective cases, i.e. the prosecution and defence, as follows. The Crown case is that the defendant was angry at the sight of the bike approaching her. She could have stopped, could have stepped aside, but instead kept moving forward, shouted angrily, striking out in anger, and, whether that blow connected or not, caused the cyclist to topple slowly sideways, perhaps in apprehension of a blow, and the key wording here is perhaps in apprehension of a blow. We'll come back to that in a minute. That's the Crown's case, and the Crown say that if you apply the legal directions, there can only be one outcome. The defence say, essentially, that she may have been taken by surprise by the sight of a bike coming down the pavement, feared for her safety, and acted instinctively. Accident or self-defence. So the Crown said that Auriol Gray was acting angrily, striking out in anger, and whether or not it connected, it caused Mrs. Ward to topple sideways, and ultimately, sadly, she was killed. The defence said, by contrast, that it was either just an accident or that Auriol Gray was acting in self-defence. Now, the important bit here was the words perhaps, because the Court of Appeal here said, even if this accurately encapsulated the prosecution's case, it followed from this that the prosecution case taking at its highest was that Mrs. Ward perhaps apprehended a blow. But this then went to the underlying offence, which was whether or not there was an assault which underpinned the charge for manslaughter. And the Court of Appeal went on to say here at paragraph 29 that it was not enough for the prosecution to prove that Auriol Gray's conduct may have caused Mrs. Ward to apprehend immediate unlawful force. The prosecution had to make the jury sure that her actions did have that effect. The jury were simply never asked to consider this as an issue. So the reason that it's surprising is that this case appears to have gone forward on the mere assumption that everybody accepted that this was an angry gesture directed at Mrs. Ward, which led to her falling. It went on. The prosecution appeared to have approached the case on the basis that hostility on the part of Auriol Gray was enough to establish that her actions were unlawful. The legal directions did nothing to correct that misunderstanding, because this judgment also referenced the route to verdict that the judge would have directed the jury, i.e. going through the steps of whether they consider it to be accident, whether they considered it to be self-defense. The Court of Appeal also noted that there was no focus on Auriol Gray's state of mind. There was no identification as to what needed to be appreciated to establish recklessness. There was no attention given to whether she recognized that there was a risk to Mrs. Ward apprehending that she'd be violent towards her. The jury were not asked to determine what circumstances were known to her or to decide whether she ran an unreasonable risk in those circumstances. The mental element of common assault was simply not addressed at all. And then the court went on to consider the CCTV evidence to say that the prosecution and the judge had invited the jury to draw particular focus on the CCTV evidence. But then the court said that that evidence plainly could not establish what state of mind either woman was in when they encountered each other. The state of mind, of course, being one of the key elements of many different offences, including the one at hand here with common assault, because there needs to be both the act and the mental element in most offences, unless they are what we call a strict liability offence. For example, the possession of illicit substances. There's no need for a mental state. The mere possession makes out the offence in those cases. But here we do need the mental element. And yet the court said that the CCTV here simply could not establish the state of mind of either party when they encountered each other. The court went on to say that had the prosecution been able to overcome the first hurdle, that is the act of what she actually did to be common assault, then the state of mind would have been the focus of attention. So the evidence presented at that trial may have been different had these issues been properly identified. And so there does appear to have been some level of assumptions made at this trial as to what happened, and in doing so, the prosecution ultimately lost sight of the underpinning offence to the charge of manslaughter. The court did respectfully recognise the distress that this will have caused the family and acknowledge that this appeal may add to that distress. The court went on to say that the actions that day led to the very sad death of Mrs. Ward, but it seems that this was the starting point for the prosecution. But had she not died, the court said that it regarded it as inconceivable that she would have ever been charged with assault in those circumstances where it could not be established with any certainty that physical contact was made. And so ultimately, the Court of Appeal was rather critical and said that the judge's legal directions contained fundamental and material misdirections of law, but that those stemmed from the failure of all involved to properly identify and address the issues to be determined by the jury. And had the need to identify and prove the base offence been recognised, the evidential insufficiency of the prosecution case might have been recognised. In other words, had they really focused on an underlying offence to the charge of manslaughter, they might have realised that the CCTV evidence and everything else just wasn't enough. And finally, the court said in its judgment there was simply no proper basis for her to be convicted of manslaughter in this very tragic case, and therefore allowed the appeal and quashed the conviction. So hopefully that makes some sense. It is a technicality of sorts, but a little more than a technicality in that everybody appeared to have approached the case in the same way on some sort of assumption that this was obviously a dangerous and angry act and obviously should lead to a trial. And it seems to have spiraled from there. All the while, it seems missing this underlying base offence, which was conceded by counsel at the appeal hearing. So I hope that makes some sense. I'm going to stop talking because it's getting more and more difficult. So please do remember to like the video and subscribe. And as always, thank you for watching.